Hi, everyone. It is 12:01, and we are a little past the top of the hour. We are having some audio difficulty. You might normally be hearing the intro music right now, but please don't worry. We are here, we are live, and we were very much glad to be with you. I'm, of course, Gabe Oberfield, one of your two co-hosts. Kristen Smith, of course, alternating with me, and Kristen will be the host next Tuesday. I also have the pleasure of opening up the webinar today, in addition to the agenda and other elements that I'll go through momentarily. But just remember that, as is the case every week, we are thrilled to have you with us. We also want to make sure that you, if you have questions, go into the Q&A panel at the bottom of your screen, enter them there, type them in. We can't hear you or see you, but we can certainly read what you have to say, and we will be able to respond accordingly as best possible during the live webinar or otherwise afterward. And I also want to make sure that each of you is familiar with the survey that we put forth each week with this webinar. We do read what you write in. We try to shape our programming to make sure that it is hitting the marks on what you're looking for. So please take that seriously. Please fill it out and know that it's not just going into a box. I'm taking a look at it. So is Kristen and others that are interested in making sure this programming is as meaningful and impactful as it possibly can be. So here in New York City today, it's kind of gloomy but sunny. It's one of those in-between days. And it is certainly right in the middle of summer. New York City feels like, it is at that moment where if you had any doubt that summer was here, that doubt is gone. It is, very much, a time when the city is, active, the days are long, and, it's a good time to be here for any of you looking to get your visit in order. It's a good time to come on down. But today's program is one where, yes, we have the New York City office represented by me, as well, Mark Berman, Devin Karras, but we have presenters from other corners of our firm as well. So with that, if Aaron, who is stepping in for Kristen, or rather for Kathy Purdy, if Aaron, you can advance to the next slide, please. I'll walk through the agenda formally. I mentioned Mark Berman. Mark is new to our webinar, but Mark is certainly not new to presenting. Mark is an experienced litigator with a many years practice in New York City. Mark is also someone who writes on AI and cybersecurity, including with a column in the New York Law Journal. And Mark is here to talk about AI and its applications to enhance video evidence. So more on that in a moment, and I'll introduce Mark formally. Another Mark is with us, Mark Beloborodov, who has been with us many times before, and we're glad to have Mark Beloborodov back with us. Mark is, of course, an attorney focused on intellectual property based in our Boston office, and he will be looking at AI as well, but from a highly distinct perspective relative to Mark Berman, looking at how it might apply to patenting, and in particular, the patenting of AI inventions. Devin Karras is back with us. He was on the program just last week, and we're glad to have Devin on again with more information to share. There are new ERISA regulations that were just introduced, and Devin is going to catch us up on the import of all of them. Jessica Blanchette is on the program as well. Jessica is with us from our Albany office. Jessica is, like Mark Berman, new to the program, and we are thrilled that she is with us. She'll be talking about employee retention tax credits. We've heard a little bit about this program before, but there are new and timely updates that we wanted all of you to have. So without further ado, let me turn over to Mark Berman. But with that, I'd like to, again, just provide an opportunity to introduce him. And if Aaron, you wouldn't mind, advancing to the next slide, that would be terrific. Just so that everyone can learn a little bit more about Mark. But not only does Mark sit around the corner from me here in New York City, but Mark is the kind of attorney that everyone knows. He is a staple in New York City, a litigator with a long career recently came to bond after the firm where he had been concluded its operations, and we're fortunate to have in that transaction gained Mark because he has been a terrific, if not powerful force to really anchor our New York City office. He has a ton of experience around not just litigation, but the issues on which he litigates, including cybersecurity and data privacy. He has an active background with the New York State Bar Association, has been a leader there, and has, again, been a leader here at Bond. And we are thrilled not only to have him with the firm, but also on the Tuesday webinar for the first time. So without further ado, Mark, I want to give you the floor to talk about a topic that you also covered in the New York Law Journal, but that you were gracious enough to recap for this audience in a way that allows this broader group to get a sense of why you thought it was important to write about. So, Mark, the floor is yours, and again, welcome.
Thank you, Gabe. Again, Mark Berman. I'm a commercial litigation partner in Bond's Manhattan office, and the author of 6 times a year, the column in the New York Law Journal called The Virtual Lawyer, as well as on the second department's artificial intelligence task force. AI is the watchword right now, and I thought, everyone's heard about those cases where, and it's been all over the news, where their AI hallucinates and creates cases that don't exist. But I want to bring it a little further, and there's only a couple, maybe a handful of cases in the United States on AI evidence. And I think what we'll learn from this recent case, it actually happens to come out of the state of Washington, it's Washington versus Palooka, is what lawyers and experts and people who use AI have to be concerned about. It's a criminal case, and there was a video at issue. And no surprise, we all have taken videos with our smartphones. The resolution's not the greatest. There's motion blur. So defense decided to use AI to enhance the video and to use it in the defense of the defendant, and used an AI program. So what did the AI program do? It got rid of the blur. It enhanced the picture. And there was a debate before the court of whether this was admissible or not. And there was expert testimony. And let's step back and see what occurred. The expert in support of the defendant said, well, I used AI. When asked, what was the AI trained on? I don't know. Has this platform, is this accepted in the forensic video industry? I don't know. Are there any articles or literature in using this platform to enhance a video? I don't know. So what you learn is, if you're going to use AI, you need to know what it's looked at, what it's trained on. The question was, do you know what algorithms it used? No. So what did the video enhancement look like when it was produced? Well, it changed the shapes of certain things in the video. Not good. It changed the color of certain items in the video. Not good. And it actually removed parts of the video and reinserted images that were not part of the video. It completely prevented the court from, or anyone from, doing any forensic analysis of this video. And the court ends up saying that the AI enhanced video does not show with integrity what actually happened, but uses opaque methods to represent what AI thinks should be shown. Let's all be clear. The video is not intended to show what AI thinks should be shown. It was intended to clarify, get rid of motion blur, and enhance the video. The court did not accept this as evidence. Now, no surprise, but there's lessons to be learned from this decision. that before you use AI, you need to see what changes it's made, why it's made, how it's made, what's in the black box, how does the algorithm work. So so this is a lesson for all, whether you're a litigator or anyone who's practicing law who wants to use artificial intelligence to come up with an answer to enhance something. What are the key issues? After hearing this, many of us are going to say, I don't see how AI can be used as evidence. And the answer is, right now it's a problem. It doesn't mean it will be a problem in the future as people understand and can substantiate what's in the black box. But right now, the courts are not accepting it unless you really have an expert who knows what he or she is doing to support what the AI has done and what it's trained on. The other issue that I wrote about in my article for the New York Law Journal, and it's near and dear to attorneys who practice in any fields where there are applications for fees. No doubt in a fee submission, you're putting in what fees you've charged, you're putting in what others have charged for similar types of cases. But it's become very common to support the application with AI evidence of what's the common, customary, reasonable practice in that field and what the hourly rates are. Universally, as we sit here now, courts are rejecting the use of AI for reasonable rates in applications. Again, as in the evidence issue I discussed, you don't know where the information is coming from. The lawyers who use this can't explain to the court the data points, just conclusions. And the first thing that the judge says, how do I know this is not hallucinating, just like all the other decisions we've heard about where they make up cases? How do I know that these rates are real? They just didn't make them up. They're just guessing. So right down the line, you have 3 decisions issued within the last 6 to 9 months, categorically rejecting AI evidence in support of a fee application. Same rules apply. Why did the court reject it? Because they don't know where the information has come from and the data points. Same lessons likewise apply. And I would suggest, before people use AI in support of evidence fee applications, they have to sit down and find that expert, find that professional who can be explained to the court what the AI was trained on and what data was used and why it's not hallucinating. So the point of this article and my talk today is to spell out the pitfalls, lay out the concerns, but also say there's a future. The future's not here yet, but it's on the horizon, and we're waiting to see cases and decisional authority where experts can explain why and what AI did, as opposed to just say, here's the conclusory results, and we should rely upon this, even though we don't know what's in the black box. So, Gabe, that's where we are with AI. I mean, we're going to move into some more meat and potatoes when Mark speaks about AI in the intellectual property field. But these are what's floating out there that people really need to, not feel comfortable with, but know the pros and the cons and what the concerns are, Gabe.
Mark Berman, thank you so much. Really glad that you took the time to come onto the program today and to outline these important issues. Of course, as you have more of these to bring forward to the audience, we would love to have you back on. And in the meanwhile, I found this very instructive, and I'm confident that the audience did as well. So let me now shift to the other mark on the agenda for the day, the other Mark B, as it were. This is Mark Beloborodov, who is known to many of you from his previous presentations on the Business in 2024 program. And Mark, based in Boston, is a member of our firm as well, focused on intellectual property. And I've had the pleasure of working with Mark recently, and also, of course, always enjoy what he has to say on this program. And Mark thought it would be timely and useful to provide updates in patenting AI inventions. And so with that, Mark, the floor is yours, and I look forward to learning some more. Thank you very much again for this time.
Great, great, Kate. Thank you for this intro. Hi everyone, good to be here. So if you remember, so I presented a few months ago on the issue of who owns inventions created by AI or with the user help of AI. And at the time, I mentioned that we're not talking about whether AI inventions can be patentable or how to patent AI inventions. This topic for the other day. And this day is today. I'll take 10 minutes to share some news on this topic. Next slide, please. So you may recall this slide from my previous presentation. This is kind of the anatomy of the AI solution. Of course, it is essentially a computer program that uses statistical tools to process input data and generate predictions. Before it does so, the algorithm is use training data to train a model constructed by the designer of the solution. And once sufficiently trained, it is deployed in the field and used to analyze input data. Next slide. So, previous slide, sorry. And so the focus of the talk today is these types of solutions where AI is deployed in a field as opposed to constructed prior to that. Next slide, please. So about a week ago, USPTO issued a updated guidance on patent subject matter eligibility, specifically including AI. What is eligibility? So we've been living in this regime for 10 years now, where ever since the Supreme Court decision in Alice v. CLS Bank, courts held that inventions that are focusing on abstract ideas like mathematical concepts, mental processes, and things of that nature are not patent eligible, even if novel and obvious, meaning you even don't get to be examined if your idea is too abstract. And a lot of software inventions are judged harshly, and we have to work through this framework in getting to the examination through the eligibility threshold for software. And of course, USPTO recognized that concerns have been raised that many AI inventions, so valuable in today's economy, and there's so many of them coming up, of course, can be viewed this way. Next slide. And so, responding to the executive order by Biden administration last October, talking about ways to basically handle AI innovation, USPTO continued its work and now following up on the guidance on ownership of AI inventions, now issuing a guidance update on what it means to be patent eligible in this critical and emerging technologies, specifically AI. So now, why is it important? Of course, USPTO is an agency in the federal government, Department of Commerce, and the ultimate decision on what is or is not patentable is up to the courts. But the way the agency examines applications, the way examiners are trained, matters a lot. And these guidelines used by attorneys like myself in walking examiners through our applications to make sure they're paying attention and focusing on the right things. So in this guidance, there's been some case law updates kind of explained to the examiners, as well as 3 new examples provided. Next slide. So as I said, there were 3 specific AI examples on using AI models to help examiners and inventors understand how USPTO might view their inventions. Up until now, only 1 example was AI specific out of about 40 provided in the manual of examining patent applications. And that was about training a model. So actually building an AI solution, whereas now we're talking about real life deployed products, if you will. So interesting. Next slide. So we have three examples of using neural network to detect anomalies in data sets or network traffic, kind of look for malicious attempts for network security, using a neural network to analyze speech signals to kind of clear a recording from foreground speech from background noise. And third example, how to personalize medical treatment plan. Something that I've been working quite a lot in this area myself. So nothing earth-shattering about those examples. USPTO kind of reiterated that the claims that involve integrating abstract ideas into something practical, improving another technology, for example, developing something that is new in a real sense, are eligible. And like I said, also, there is now a summaries and kind of explanations of the case law to the examiners who are not lawyers. Next slide. So some takeaways. So nothing earth-shattering really happened. USPTO kind of reaffirmed its prior stance on software inventions, meaning it's always good to have a practical application of your solution in the way it functions. But there are quite important aspects of this event that happened a week ago with this guidance. First of all, it's clear that just because invention involves AI does not mean, oh, it's just math. I don't need to think deep thoughts. It's math. It's not eligible. We've had that happen, or many examiners take that very simple view. Rather, when you have AI-based or AI-enabled solution that includes and recites particular hardware structure, practical application, such as specific medical treatment, or the way the system takes certain action, improvement to a technical problem that you identified, where AI truly used as a tool in a new and non-obvious manner, that's good. So this was reaffirmed, and that's important. And also just kind of culturally and politically, it sends the right message to the examiners that, look, there are examples. You can kind of be comfortable allowing these inventions, these applications, because yes, we do believe that AI inventions are patentable. On the other hand, examples are specific, and us lawyers like to have a lot of kind of guideposts to analyze data patterns and try to explain that we are just like this example. So we'll need more from the courts, and these 3 are just 3. And the examiners might not be willing to venture too far from the example given in the guidelines. And of course, there's myriad ways how you can implement AI in practical applications across industries. So in that sense, it's helpful, but incomplete. specifically when it comes to what if it's not earth-shattering? What if it is a very real, but just an improvement? More realistic images. Back to what Mark was talking about. Removing blur from videos. More accurate text descriptions. Better predictions of medical outcomes that are within the purview of smart humans using conventional tools, but just faster, just a little better. What about those? The other interesting takeaway is they did not dwell much on how AI model was used, but jumped right into what happens after, really on the outcome. So it kind of writing on the wall as far as what USPTO considers an important area and whether the ways how AI is deployed is less of a fruitful area for patenting. We'll see about that. But the way that they decided to focus on an end result is quite telling. Thank you. Any more questions about this? You know how to find me. Thank you.
Mark, thank you. As always, it's really, really fascinating to hear these updates. And as both Mark Berman and you pointed out, AI generally is fast evolving. The implications are myriad, and there's always more to learn. So really glad you could come on the program to discuss some of those developments. And thank you, and please come back again. With that noted, let's move to our third presenter for the afternoon, and that's Devin Karas. Devin is known to all of you. He sits in our New York City office, senior counsel focused on employee benefits. Last week, he was just remarking that it's somewhat of a quiet period. And then, of course, as soon as that said, lightning strikes and new ERISA regulations are introduced, if I have the timing right. But all of that noted, we are glad to hear from Devin because Devin always has useful information to share with the group. Devin, before I turn it over to you, I just want to respond to a query in the chat. Will a copy of the slides be available afterwards? The answer is absolutely yes. Everybody who signs into the webinar should receive an email following the webinar, both with a link to the slides themselves and other relating information. If you don't receive that information for any reason, please just contact me. So Devin, the floor is yours. Thank you again for coming back on, especially coming on just a week since your last presentation. We're glad to have you back.
Thanks, Gabe. That was a very nice introduction. Happy to be here, everybody. And yeah, as Gabe was remarking, it's been somewhat quiet recently until last week when the IRS issued new required minimum distribution regulations that apply under retirement plans, which are, of course, governed by ERISA. But I typically begin these little spiels with the general sort of call out that anyone and everyone in attendance is encouraged to reach out to me or one of my colleagues in the Employee Benefits Department regarding any topics you'd like to hear discussed on any future Tuesday presentations. So, as I said, that said, the IRS last week issued important final and clarifying regulations that are worth discussing today. They're lengthy, they're very detailed, and I think the purpose of my chat this afternoon is to just kind of remind you that they were issued and go over a very quick summary of what they entail. In the time allotted, I won't be able to go through everything. This will just be a very light touch on a very broad description of what is essentially at issue in the new regs that were published. So as many of you sponsoring retirement plans may already be aware, the Setting Every Community Up for Retirement Enhancement Act, known as the SECURE Act, passed in 2019, and the SECURE Act 2.0 passed in 2022, together made some pretty significant changes to retirement plan RMD rules, or otherwise called required minimum distribution rules. So very quickly, as a lightning fast refresher, prior to passage of SECURE and SECURE 2.0, the Internal Revenue Code required that participants in retirement plans, generally tax qualified plans, be required to receive minimum retirement plan distributions of a minimum amount called required minimum distributions, or RMDs. They had to participants have to receive these RMDs historically upon the later of their retirement or April 1 of the year following the year that the participant attains age 70 and a half. It's the age 70 and a half, or the April 1 of the year following the year of attainment of that specific age is generally known as the required beginning date. The code also included rules regarding how quickly participant retirement benefits would have to be distributed if the participant dies on or after the required beginning date. The RMD rules are important, and they're in place to ensure that retirement plan participants can't keep their benefits locked up in a retirement plan in perpetuity. The most important reason from the government's perspective is that they need the tax revenue. For those of you with plans, you're already aware of this. It's the contributions that participants make are tax deferred up front. And so the goal is it will be taxed on the back end when you retire. But, of course, if you're leaving your money in your retirement plan forever, the government doesn't get their money back. So that's the purpose of these RMD rules. So recognizing that employees are living longer and may need their retirement benefits to let it last a little bit longer too, Secure and Secure Act 2.0 tweaked the RMD rules to extend the deadline by which are required beginning the distributions need to be made, or extend the required beginning date. Again, this may be familiar to many of you, but the regulations were just issued and they're effective sort of early next year. And I'll get into that later. But instead of the required beginning date beginning April 1 of the year following the participant attains age 70 and a half, again, for years, that was the standard. It was the April 1 following age 70 and a half. The required beginning date is now dictated in accordance with the kind of like a schedule that the IRS published as part of these regs and as part of the Secure Act, or as part of Congress issued as part of the Secure Act and Secure Act 2.0. So the required beginning date is now April 1 of the year following the later of the year the participant attains his or her, quote, applicable age or retires. So if you're an employee born before July 1, 1949, the applicable age is 70 and a half, the way it's been. If you were born on or after July 1, 1949, but before January 1, 1951, the applicable age is 72. So again, it would be the required minimum distribution would have to occur April 1 of the year following the year in which you would attain age 72 or otherwise retire. If you're born on or after January 1, 1951, but before January 1, 1959, the applicable age is age 73. And if you're born after January 1, 1960, the applicable age is 75. Again, this is Congress recognizing that people are living longer, working longer, and to require people to take distributions at that age is sort of antiquated. Again, age 70 and a half requirement is somewhat antiquated. So another highlight of the rules articulated through Secure Act and Secure Act 2.0 concern the pace at which required minimum distributions must be made. And the new regs allow some flexibility as to how quickly such payments must be made to dead participants, designated beneficiaries, or eligible designated beneficiaries, which again is a new sort of iteration under Secure and Secure Act 2.0, which is defined in the new regs that were issued. So as an example, if you're a participant in a defined contribution plan and you die before your required beginning date, the final rules, again, they just clarify that distributions must be made within 5 years of the employee's death if he or she does not have a designated beneficiary, within 10 years of the employee's death if the designated beneficiary is not an eligible designated beneficiary, and if the employee has an eligible designated beneficiary, distributions need to be made over the life expectancy of the eligible designated beneficiary. The new, again, this is very complicated stuff. This is a very quick highlight, but we're here to help you if you have any questions. The new regulations allow plans to avoid some of this complexity about, the scheduling for payments for designated beneficiaries in the event of a deceased participant before the required beginning date. They allow plans to avoid some of that complexity I just mentioned and apply a more restrictive use of some of these timelines. So, for example, a plan won't violate 401A9 or the required beginning date and RMD rules And if the plan specifies that the 10-year rule rather than the life expectancy rule will apply with respect to all employees with an eligible designated beneficiary. So you can kind of sort of circumvent that life expectancy rule if you choose to, according to the right rules and regulations. Contrary-wise, on the flip side, the new rules also allow a plan will not violate the RMD rules if they allow participants to essentially elect the timeline. So if you elect a eligible designated beneficiary to choose either the 10-year life or life expectancy rule, provided there's a default in place. In case you're wondering, the new regs, they define with particularity what an eligible designated beneficiary is. It would be a surviving spouse, a child, a disabled person, or a chronically ill person. And the regulations go into further detail about how those sort of eligible designated beneficiary categories are defined. Again, not for a 10-minute presentation, but just for your sort of edification, that goes into the level of detail of what the regulations provide. So this is just, as I said from the top, this is a really minuscule, small little taste of what the new rules say, the detail that they articulate. Again, they're very lengthy and very complicated. I could go on about how the new RMD rules apply for defined benefit plans, how they apply for Roth 401k plans, or I'm sorry, for a 401k plan with a Roth 401k account, and how they're exempt from the RMD rules. They're endless. They're very dense. It's about 60, 70 pages. But the point of my conversation in general was to inform you, A, that the rules are out, which is important, to let you know that they're effective as of September 17th of this year, that they apply for minimum distribution for calendar years beginning on or after January 1, 2025, and that written amendments aren't due until 2026. So what this means is that plans need to operate in accordance with the regulations beginning in 2025, but you don't need to have a formal written amendment until the year after. And the final regulations go into some detail about what your actual final written plan amendment would need to require to pass muster with the IRS to maintain plan qualification. So again, it's kind of reminding you to sort of get up to speed on some of these things as the new year approaches. I know it's only July, but it'll be here quick enough. And as always, we're here and we're always happy to help answer any questions you might have about implementation, about drafting the amendments, and anything else related to these new regs and anything other, any employee benefits questions you might have. So that's it for me, Gabe. I don't know if I'm over time or under time, but I'm hoping that, that's basically what I have today.
Devin, that's really useful. Thank you. And we look forward to having you back on following that September 17th go live date, or whenever it is that there's new news relating to the area you cover. And thank you for reading those 60 to 70 pages on our collective behalf. We appreciate it. And so let's turn to Jessica, who is our final speaker for the day. And Jessica has not been on the webinar before. So first, welcome, Jessica. Jessica is with us from Albany. And for those of you who don't know Jessica, she is a business attorney who focuses on corporate and business law, property, tax, and she is someone who has been educated in Albany as well, including Siena College and Albany Law School, and sits in our Albany office. She is here to talk about the Employee Retention Tax Credit Program, which we've spoken to you about previously with a number of presenters. This program has received a lot of attention because of various allegations of impropriety. And so Jessica's here to talk about where things are right now. And Jessica, we're really glad to have you on the program. Welcome. And we're hopeful this is the first of a number of presentations to come.
Great. Thanks, Gabe. Very happy to be here with everyone today. So as Gabe said, my name is Jessica. I'm an attorney in Bond's business department and tax practice group here. And I'm here to provide an update on the Employee Retention Tax Credit, or the ERTC. So as Gabe said, we've talked about this before, but I'll give a quick brief background. The ERTC is a refundable payroll tax credit available to certain eligible employers that kept paying their employees despite the shutdowns during COVID-19. Unfortunately, as Gabe said, and as we all know, almost instantly this program became rife with fraud and abuse. So specifically towards the end of 2022 and throughout 2023, we saw an uptick in what we're calling, these third-party promoters. So these people offered ERTC eligibility review and tax preparation services in exchange for a percentage of the potential amount. So they claim, they're entitled to these funds, even if the employer never actually receives the credit. So as you can imagine, these third-party promoters aggressively marketed their services and overpromised eligibility to businesses that were clearly not eligible for the program. The IRS became quickly inundated with ERTC claims. Most of these were questionable at best. So as a result, the IRS did react eventually. September 14th, 2023, they placed a moratorium on the processing of new ERTC claims so that they could kind of review what they've got, work through their backlog, come up with a strategic plan moving forward. So that's kind of what today's update is about. So the IRS did review approximately 1 million of their unprocessed ERTC claims that represented more than $86 billion. As a result of this review, they announced their plans to categorize the claims into 3 groups or buckets, and either process or deny immediately, or they'll conduct further review of a select few. So after their review, the IRS announced that between 10% and 20%, only 10 and 20% of the claims exhibited no eligibility warning signs. And those claims are expected to be processed immediately, with the first payments expected in late this summer. So hopefully, the IRS's goal is to get these moving. There are certainly proper claims that were filed and they've just been buried. So the IRS is making a point to kind of pull those out one by one and get them moving and get relief to businesses who do deserve them. So then the IRS found that between 60% and 70% of the claims showed what they're calling an unacceptable level of risk, where it shows enough not to process immediately, but also not enough to outright deny the claim. The IRS has announced that they will be conducting additional review of these claims before making a final determination. As you can expect, this will probably take several months or at least a good amount of time to go through. And then the IRS found finally that the final 10% to 20% of the claims exhibited clear eligibility warning signs, things that just knock them right out immediately, and those claims are expected to be not denied immediately. So at this point in time, business owners who do have pending ERTC claims don't need to take any action. The IRS has actually asked that you don't contact them because it's only just going to kind of add to their backlog. But they did say that, be on the lookout for communications, check your mail. If you have powers of attorney, tell them to be on the lookout for any potential notification from the IRS. The IRS has also encouraged businesses during this time to kind of do a double check on themselves to see if, they do in fact think that they are eligible for these credits. And instead of going back to kind of the third-party promoter that they were working with before, the IRS has encouraged maybe reach out to a trusted tax professional or a legal professional who can kind of review the submission as a whole and I guess do a reevaluation as to whether the business is truly eligible for the ERTC. The IRS has encouraged business owners to apply for the special withdrawal program as well. So if, you do kind of take a second look at your ERTC submission and see that, hey, maybe, I'm not eligible, or the likelihood of the business being eligible is not high, there is a withdrawal program that the IRS offers. And so this allows business owners to request that the IRS not process the pending claim. And there's also an option there with, even if the claim has been processed and a check has been issued, if a business owner doesn't cash the check and instead returns it and goes through this withdrawal program, the IRS will accept it as if the claim had never been filed. And so what both of these things do is avoid penalties and interest for claims that maybe have been improperly paid out, that the IRS will eventually find out and pull back. Or, it's kind of like a voluntary disclosure, I guess. It allows business owners to proactively take charge of these claims and, hopefully avoid penalties and interest in the process. Finally, the last thing the IRS did announce is that they are considering reopening their voluntary disclosure program specifically for the ERTC. And that was a special limited time program. It was earlier this year. We did write a client alert about it. It was just, I think it was only for a couple weeks that it was open. But they are talking about reopening that program with a little bit of a cutback on it. And a decision on that is expected in the next coming weeks. So for now, anybody, if you have pending ERTC claims, keep a lookout for any notices for the IRS. We do recommend you kind of reevaluate your claims, see if they are valid. If you want to discuss any notices you get or that, we are available. Please feel free to reach out to us or the attorney that you are in regular communication with.
Jessica, thank you. That's a really helpful summary, and it catches us up in terms of what's going on with that program. Again, one that has endured a significant amount of scrutiny, and now we have a sense in terms of how the IRS, is stratifying that approach to getting through the work of processing these claims. So please come on back if you hear anything else that's new and worth the time of this audience, as we know many of you as businesses tuning in engaged with this program, and certainly I've been involved in some of that work of trying to get out of those arrangements. I know that your practice group and team as well has been involved. So as Jessica noted, please do reach out if you are listening and you're thinking, perhaps this is me. With that, let's though note the time and make sure that all of you have the best opportunity to reach us if you have questions and follow up. And let me again thank Jessica first and foremost for coming on the program. And if Aaron, you go to the next slide, we can, and the one thereafter, we can provide email addresses. Thank you of all of the presenters. They're arrayed here. You can always reach out to me if anything comes up and I can be of help to you. Our next program is scheduled for the last Tuesday of July. That is the 30th. And when you come on back, you'll be not hearing from me, but it'll be Kristen Smith who will be the host. I will be back with you during the first week of August. In the meanwhile, I'm wishing you all a continuing good summer. And I thank all of those presenters today who have come on to provide us with content. We thank you for your loyalty to the program, and we wish all of you a good balance of the week. Be well.